Showing 9 o'clock. Are we ready to start?
You don't have to leave. Yes, you can move them.
All right, hello, welcome aboard. It looks like our chair and the rest of our staff are ready to go, so we'll get started. You'll note, same thing here, these new mics. We got typically when you get the green, it's on. It's the reverse, the red's on. So you'll have to press it to get it. It won't just register your voice. Typically, you'll have to press it and then release it after you're done. If you leave it on, then you'll get some feedback from others as they try to speak as well. All right, so, Chair, are we ready for business?
All right, the notice of the May 16, 2024 meeting of the Board of Examiners for Land Surveyors, including date, time, and location, has been noticed to the Land Surveyors website since July the 5th, 2023. Additionally, this month's agenda has been posted on the website since May the 7th, 2024. And with that, we're ready to call order.
All right, for the roll then, we've got Jay Kaufman.
Here.
Gary Clark.
Here.
Kevin Martin.
Here.
Justin Raines.
Here.
All right, Chair, we have quorum. I think we're ready for a couple items before we get into the rulemaking hearing. We'll just need to approve the agenda, February minutes, and then quick little professional society report, and then we'll launch off into the rulemaking hearing. So agenda, do we have any changes or edits there?
Motion to approve the agenda is published.
Second.
All in favor?
All in favor, say aye.
Thank you,
Aye.
sir. I'll let.
All right. February minutes is, I assume everyone has had a chance to read over those, or any changes or amendments to the minutes.
Motion to approve if no changes.
We have a motion.
A second.
All in favor, say aye.
Aye.
Very well. And we're ready for our professional society report. We have,
Good morning, everybody. Can you hear me?
Morning, Jimmy.
yes,
Hey, how's everybody doing today?
Good now.
Good. Appreciate the opportunity to attend virtually. Sure helpful for those of us from West Tennessee. Real quick this morning, as everybody knows, we had our TAPS conference back in March. Successful. By now, everybody should have gotten their continuing education certificates by via email. If you have not, reach out to Ken Shreve, Lori, or myself, and we'll try to track down and get you those copies of your certificates. Final numbers on the conference should be released to the TAPS board at the June 1st meeting here in a week or two, and the courses for our next year's conference have already been lined up and submitted for approval. So I'm trying to get a jump on that for next year. And so far, as you all are aware, we've had the legislation was passed by the General Assembly, and starting to get some positive feedback on that through the membership and other surveyors. So right now things seem to be going pretty good, and just kind of hopefully gearing up for a busy summer for everybody, and trying to get a head start on next year's conference.
thank you, Jimmy. Any questions for Jimmy while we've got him? Hearing none, we'll move on to the rulemaking hearing. And who administers that?
That would be me.
Yeah.
Okay. This rulemaking hearing is called to order. My name is Stuart Huffman. I serve as Associate General Counsel in the Department of Commerce and Insurance, Division of Regulatory Boards, and I represent the Tennessee Board of Examiners for Land Surveyors. Would the agency representatives who are present introduce themselves for the record, starting with Glenn, please?
Glenn Kopchak, Executive Director of the Land Surveyor Board.
Introduce yourself, please.
Oh, Gary Clark, Chairman of the Land Surveyors Board.
Jay Kaufman, Vice Chairman.
Justin Raines, middle member. Kevin Martin, public member.
Thank you. Today is Thursday, May 16th, 2024. This rulemaking hearing is taking place pursuant to Tennessee Code annotated Section 4-5-204 in Conference Room 1B of Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee, and also available by electronic means via Microsoft Teams, which can be located on the board's website at www.tn.gov/commerce/regbboards/surveyors/public-meeting-information.html. On this page, the link for access to this rulemaking hearing via Microsoft Teams can be found in the chart located in the middle of the webpage in the second row with the date 5/16/2024 in the location column under the words Nashville, Tennessee labeled Connect. The purpose of this rulemaking hearing is to solicit comments on rule amendments to the rules and regulations of the Tennessee Board of Examiners for Land Surveyors. The proposed rule amendments update the definition of Global Positioning System, GPS, to include reference to Global Navigation Satellite Systems, GNSS. GPS refers to the North American Global Positioning System, and GNSS refers to the International Multi-Constellation Satellite System. GNSS encompasses GPS as well as other constellation systems, providing for a more accurate and reliable capture of data that can be used by licensed land surveyors in their practice. Language is added to state that GNSS equipment may be used in gathering measurements in the course of a survey. Minimum standards for remote sensing surveys are updated to delete those requirements surrounding GPS, and GNSS standards are incorporated. Additionally, this amendment provides a general cleanup of terminology in order to reflect more up-to-date language currently used in the profession. Specifically, the definitions section is amended to state that the terms survey plat and survey map may be used interchangeably. Throughout the rule, the term survey plat replaces survey map due to survey plat being the industry standard. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, then end of which time will be the effective date. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet to my left located on the podium. Those members of the public wishing to speak and appearing via Microsoft Teams should put their name in the chat box. Oral comments will only be accepted by those who have written their name on the sign-in sheet or typed their name in the chat box. Is there anyone else that desires to offer oral comments but have not written their name on the sign-in sheet or typed their name in the chat box?
Excuse me, there's not.
Seeing that there are none, for those attending this in person, I would call your attention to the table located directly behind me to the right. On this table, you will find red-line copies of the rule amendments addressed in today's rulemaking hearing. For those attending on Microsoft Teams, you will find a link in the chat box to the red-line copies of the rule amendments for today's rulemaking hearing. The notice of rulemaking hearing included the entire text of the proposed rules and were published on the Tennessee Administrative Register website on February 22nd, 2024. An e-notify was also sent on February 2nd, 2024. I will summarize the substance of the proposed rules into the record. Rule 0820-03-.035 definitions is amended by adding the definition of global navigation satellite systems of GNSS as a network of orbiting satellites providing the navigation and position data necessary to determine the location on the Earth. Systems that comprise the GNSS include Navstar, GLONASS, Galileo, Compass, and any other satellite-based navigation and positioning systems. For purpose of this chapter, Global Positioning Systems, or GPS, shall have the same meaning as GNSS. Rule 0820-03-.054, accuracy of surveys is amended by adding the following language: that it is acceptable practice to incorporate the use of GNSS equipment to any survey. Rule 0820-03-.06, maps and mapping, is amended by renaming the rule survey plats and mapping and replacing survey maps with survey plats throughout the rule. Rule 0820-03-.07, survey types and requirements, is amending by deleting minimum standard requirements for using GPS and incorporating minimum standards for using GNSS equipment. Rule 0820-03-11, global positioning system surveys, is amended by deleting the text of the rule in its entirety. Throughout Chapter 0820-03, Standards of Practice, there are general cleanups of terminology in order to reflect more up-to-date language currently used in the profession. As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit each comments if they become repetitive. Please limit your comments accordingly. Before I take public comments, I will read comments that I have received via email prior to this hearing. An email from Jacob Forster with ETN Surveying. He states, one quick note. Proposed changes to Section 5, Remote Sensing Surveys, A3, states, and whether single or dual frequency receivers were used. Number one, if the manufacturer and model are required information, then this statement is redundant. Number two, virtually all receivers sold in the last 5 years are known as triple frequency receivers. Requiring a statement as to single or dual frequency is already an outdated statement based on outdated technology. Furthermore, a convincing argument can be made that there are many more frequencies utilized than just triple frequency. 3, simple removing the words and whether single or dual frequency receivers were used, but retaining the manufacturer and model statement would preclude either redundancy or conflict between the standards of practice and the actual equipment utilized. Is there any comment from the board? All right. The second email from Mike Payne with Bird Surveying. I recently received the proposed changes to the standards of practice, and I would like to offer modifications to the changes as follows. Page 7, item E, the elements of the horizontal curve that are listed as a minimum should be expanded to include the delta angle of the curve. This element is a major component in the definition of a curve. In the case where the curve has been designed, such as in a subdivision, typically the two elements that are defined are the delta angle and the radius, and occasionally the tangent. These two elements tend to be fixed values where no rounding has been applied. The property makes the delta free of any uncertainty. The remaining elements, length, long chord, and chord bearing, may be derived from the delta and radius to a greater degree of accuracy than is typically stated in 2 decimal places. This is of no great concern if a single curve is under reconstruction. However, if a section of a road is involved, the error will accumulate. Therefore, I believe that the inclusion of the delta angle to the nearest second, along with the other elements listed, should be the minimum data shown for a horizontal curve. Page 8, item G. There is no reference to a situation where a contour line is defined as the boundary of a property. This is common along TVA reservoirs where property ownership extends to a contour. In this instance, the contour should be defined by chords along it at intervals that will not exceed a distance specified by the standard from the contour location. The endpoints of the chords should be marked by monumentation as specified in the standards, as these points should be treated as corners. The Board of Examiners specified this in a letter to me about 15 years ago and should be part of the board minutes. Page 8, item H4. The rule should specify that the monument at the prolongation of such line must be set on the subject property. The line should never be extended onto the adjacent property where the monument will only create confusion. Is there any comment from the board? All right, Mr. Kopchak, are there any other written comments received by the board's office regarding these rules?
There were not.
Are there any public comments from those present at today's meeting, either in person or via Microsoft Teams?
There are none. Oh, we do have a quick comment.
Very quick, I just wanted to say I appreciate the work that y'all put into this. I think the rule changes are, thank you, are pretty concise. I did have one question, and I apologize for not submitting in writing. There's not a requirement in there to depict gores or overlaps. There is a requirement in the law to analyze adjacent descriptions, but I didn't know if there was a reason or a thought as to why that would not be required, as that's what forms a lot of property disputes and title insurance claims and things. And other than that, I just appreciate y'all serving. I served on the board in Georgia for 18 years and just always wanted to come to a Tennessee meeting and never could, but thank y'all and good job.
And do you mind just stating your name for the record as well?
My name is Mark Chastain, Tennessee 1937.
All right, thank you, sir. Okay.
Now I will close the public comment portion. Lastly, there are several measures I will need to adopt by motion and roll call vote as required by TCA 4-5-222. First, I will need a motion to adopting the hearing rules language as amended, if amended, but none of this has been amended, so I need a motion to adopt the hearing rules.
So moved.
Second.
Got a motion from Mr. Kaufman, a second from Mr. Raines, and I'll just do a roll call vote then and run down the line. Jay Kaufman,
Yes.
Gary Clark,
Yes.
Kevin Martin,
Yes.
Justin Raines.
Yes.
Thank you.
Next, I will read the regulatory flexibility addendum pursuant to TCA 4-5-401 through 4-5-404. Prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule affects small business. Number one, the extent to which the rule may overlap, duplicate, or conflict with other federal, state, and local government rules. The proposed rules do not overlap, duplicate, or conflict with other federal, state, and local government rules. Number two, clarity, conciseness, and lack of ambiguity in the rule. The proposed rules are clear, concise, and ambiguous. Efforts to promote clarity were undertaken during the drafting of these rules. Number three, the establishment of flexible compliance and reporting requirements for small businesses. Small businesses will not be drastically affected by these rules. Therefore, allowing separate compliance and reporting requirements would generally not be necessary nor feasible. Number four, the establishment of friendly schedules or deadlines for compliance and reporting requirements for small businesses. These rules do not affect the schedules or deadlines for compliance and reporting requirements for small businesses. Number 5, the consolidation or simplification of compliance or reporting requirements for small businesses. As drafted, these rules accommodate small businesses in Tennessee in the most efficient manner. Number 6, the establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule. These rules do not create any new performance standards for small businesses in comparison to design or operational standards. Number 7, the necessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. There are no unnecessary entry barriers or other effects that would stifle entrepreneurial activity created by these rules. I will now need a motion to adopt the regulatory flexibility addendum by roll call.
So moved.
A second.
Got a motion by Mr. Kaufman, a second by Mr. Martin, and for a roll call vote then. Jay Kaufman,
Yes.
Gary Clark,
Yes.
Kevin Martin,
Yes.
Justin Raines.
Yes.
Thank you.
I will now read the impact on local government statement pursuant to TCA 4-5-228. The Tennessee Board of Examiners for Land Surveyors foresees no impact on any local governments. I will now need a motion to adopt the impact on local government statement by roll call.
Motion to adopt?
Second.
Got a motion by Mr. Kaufman, second by Mr. Raines. Roll call vote. Jay Kaufman,
Yes.
Gary Clark,
Yes.
Kevin Martin,
Yes.
Justin Raines.
Yes.
Thank you.
I will now read the answers to the questions required by the Joint Government Operations Committee. All agencies, upon filing a rule, must also submit the following pursuant to TCA 4-5-226 I-1. A brief summary of the rule and a description of all relevant changes in previous regulations effectuated by such rule. The rule updates the definition of Global Positioning System, GPS, to include reference to the Global Navigation Satellite Systems, GNSS. GPS refers to the North American Global Positioning System, and GNSS refers to the International Multi-Constellation Satellite System. GNSS encompasses GPS as well as other constellation systems, providing for a more accurate and reliable capture of data that can be used by licensed land surveyors in their practice. Language is added to state that GNSS equipment may be used in gathering measurements in the course of a survey. Minimum standards for remote sensing surveys are updated to delete those requirements surrounding GPS, and GNSS standards are incorporated. Additionally, this amendment provides a general cleanup of terminology in order to reflect more up-to-date language currently used in the profession. Specifically, the definition section is amended to state the terms survey plat and survey map may be used interchangeably. Throughout the rule, the term survey plat replaces survey map due to survey plat being the industry standard. B, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. There are no known federal or state laws or regulations mandating promulgation. C, identification of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of this rule. The proposed rules most directly affect currently licensed land surveyors and those wishing to apply for land surveyor's license. The Board of Examiners for Land Surveyors urges adoption of these rules. D, identification of any opinions of the Attorney General and Reporter of any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. There are no known opinions of the Attorney General and Reporter or any judicial rulings that directly relate to these rule amendments. E, an estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget, or $500,000, whichever is less. There is no foreseeable probable increase or decrease in state and local government revenues and expenditures resulting from the promulgation of this rule. F, identification of the appropriate agency representative or representatives possessing substantial knowledge and understanding of the rule. Stuart Huffman, Associate General Counsel, Board of Examiners for Land Surveyors, Department of Commerce and Insurance. Glenn Kopchak, Executive Director, Board of Examiners for Land Surveyors, Department of Commerce and Insurance. G, identification of the appropriate agency representative or representatives who will explain the rule at scheduled meeting of the committees. Stuart Huffman, Associate General Counsel, Board of Examiners for Land Surveyors, Department of Commerce and Insurance. Glenn Kopchak, Executive Director, Board of Examiners for Land Surveyors, Department of Commerce and Insurance. H, office address, telephone number, and email address of the agency representative or representatives who explain the rule at a scheduled meeting of the committees. Stuart Huffman, 500 James Robertson Parkway, Nashville, Tennessee, 37243, 615-741-3072. Stuart.Huffman@tn.gov. Glenn Kopchak, 500 James Robertson Parkway, Nashville, Tennessee, 37243, 615-741-9129. Glenn.Kopchak@tn.gov. I, any additional information relevant to the rule proposed for continuation that the committee requests. No additional information requested. I will now need a motion to adopt the additional information for the Joint Government Operations Committee by roll call.
Motion to adopt? Second?
Got a motion? There we go. We got a motion from Mr. Kaufman, a second from Mr. Raines. For a roll call vote then, Jay Kaufman,
Yes.
Gary Clark,
Yes.
Kevin Martin,
Yes.
Justin Raines.
Yes.
All right, we captured a yes then for each of those. Sometimes these can be a little difficult when we're doing roll call votes because there can be too many mics on, and then that creates some of that feedback. So
I think the problem is we haven't figured out what the green flashing light means.
that's when it does that, just pause for a second, let it kind of work it out. It's just having a hissy fit, you know. You just gotta. It's basically saying you've got other mics on there and there's running interference. It's a wait prompt is what it is. So just wait and then hit it. Okay. All right. Looks like that was covered. Ready for the next one?
That concludes this rulemaking hearing. Following this hearing, the rules will be put on rulemaking filing form SS-7039, submitted to the Governor's Office for final review, and then submitted to the Attorney General's Office for review and approval. Once Attorney General's signature is obtained, they are filed with the Secretary of State and generally become effective 90 days from the date of filing after receiving a positive recommendation from the Joint Government Operations Committee. Thank you for being here today.
I'd like to just take a brief moment, since the rulemaking hearing is complete. Chair, if it pleases the board, I'd like to make an introduction and also give our court report an opportunity to sort of pack up since we're done with the rulemaking hearing. So while she's doing that, if I may, yeah, well, what's that?
Do you want a 5-minute break? Or?
Well, let me just do one thing on the record, then we'll take a 5-minute break if that's okay. Yeah, that sounds great. So, Alex Martin, of course, our current Assistant Commissioner, he'll be taking on a new role. His new role will be Chief Strategy Officer, working directly under Commissioner Lawrence. When I first heard that that was going to be his role, I thought, what a perfect fit. I mean, when it comes to processes improvements, that's right up his alley. So I'm looking forward to him implementing the strategic plan for Commerce and Insurance department-wide. So that'll be exciting to see him being put to work up there. So that leaves a vacancy. And Reed Witcher, he is our legislative director right now. So he's been with us for a while, which is nice to have that continuity. And if I may just have him stand up and wave to you there. There he is. And then when we take our break, have an opportunity to speak to him individually for a few moments. But he's no stranger to the Hill and to government. I've been in this business for a long time. Come legislative session, we're going to be in good hands. So all of this is not for him. And one nice thing too is one of his main areas was reg boards. He had folks that were going up there, so he's very familiar with our programs already. So he should be able to hit the ground running. So I'm excited about that and looking forward to the impact he's going to have as he steps into that role. And that'll probably happen around June 3rd-ish. So they've got a transition plan in place to make sure everything goes smooth, and that handoff will be clean and will benefit everyone that will be affected. So with that, Chairman, if you're okay, may we just take a brief recess, about 5-10 minutes?
Yeah, we can take a short break for 5 minutes, just to give them time to pack up.
Thank you, Gary. Thank you. Chair, it's
All right, I guess we can call it back to order.
Yes, sir. All right.
Yep.
Looks like we're ready for our next section, which is the education report. Let me get there myself.
Yes, any questions or thoughts on the approved ones that come out?
No questions, anything at all. It all looks familiar, quite honestly, as I get the opportunity to review many of these. Quick kudos to Philip here for distributing these in a timely manner, and hopefully we all reciprocate and get them back to him. But he's very thorough, so I appreciate his efforts there.
All right. Nothing else there. Let's see, I guess that takes us to the,
Oh, yeah, we'll just need a motion to accept that and to
Okay,
the whole
have a-
thing. We won't do after the roll call hearing since we're out of the rulemaking hearing, so that's nice. We can go back to a voice vote. Sorry,
Okay.
Chair. Go
have
ahead.
a motion to accept the education report.
So moved.
Second?
Second.
Okay, all in favor say aye.
Aye.
Very well. Then we move to our application review.
Okay. Get there myself. And, all right. All right, we have a renewal applicant in front of us. There was, had pending discipline or has pending discipline in Kentucky that was not resolved, resulting in a revocation of license there. Let me just put the statute in front of you for why you're reviewing it now. TCA 62-18-116A1 states the board may refuse to issue a certificate of registration, may revoke, suspend, or refuse to renew a certificate of registration, or may take other lawful disciplinary action against any land surveyor registered under this part for any of the following causes. The two causes for which we're looking at today is B and F. The potentiality there, as stated, is any incompetency, misconduct, or gross negligence in the practice of land surveying. And then F, any revocation, suspension, disciplinary action, or voluntary surrender of a license or certificate of registration to practice land surveying in any jurisdiction. So it's a renewal, and I suspect we also have our subject or our application, our applicant in front of us as well. It's Mr. Fitch on. There he is. Okay. So our applicant's also online. So if you had any questions, direct to him as you consider his renewal and the application before you, you can do so and direct those accordingly.
Okay. So, Mr. Phillips, you're there with us, okay. Did you hear us all right?
Mr. Foote, your mute's on. Let's try it. Can you?
All right.
We can't hear him yet. Let me see if we can. Hold on just a second. Mr. Futch, if you can try on your end and see if you're on mute. Are you unmuted on your end? Okay, yeah, I can't hear you. We've got maybe it's on this. We're gonna make sure it's clear on our side. If you can just make sure it's clear on your side as well. And then also you have the chat box there. If you want to utilize that until we can get this remedied.
For your layout. Because he's going to need. Carlos, that's about those variants.
We can hear you now, Mr. Futch. You were
Okay.
good. You're
I
coming
can hear
through.
you very well.
All right, good deal. Welcome back. Thank you to the team also for troubleshooting that and sort of chasing those rabbits. Heidi and Alex, appreciate y'all. Okay, Chair, you were saying?
Okay, so I guess if we're back online and Mr. Fitch, you can hear us and we can hear you now, I guess. Good.
Yes.
All right. Just a quick synopsis for me. I assume you all have had this and had a chance to read it. It appears that Mr. Fitch came under a disciplinary action with the Kentucky Board. We have included in this the investigator's file and their facts and their ruling, and it comes down to a consent order that the Kentucky Board had leveled onto him, and I see that it is, Ms. Foots actually signed it, which is an agreement to the consent order. And then the last bit here, we have that the current issue is that the consent order has not been complied with. And I guess that's a summary as I see it. Would you like to elaborate or comment on that, Mr. Fudge? That's kind of brief. I didn't want to have to read the whole thing, but.
Yes, sir, that's fine. The whole process of the investigation, everything came after I'd already let my license lapse in Kentucky. I had moved out of the state and was no longer working there. So I had already let my license lapse, was no longer keeping an active license in Kentucky. So all this came up, and a big part of their ruling was I had to notify them of jobs that I was doing, and they would pick some jobs during the course of the year to come and review and this sort of thing. I've had no way to comply with that, so I technically have not complied with all of what they have said I needed to do.
And there was initial fine, I think, in there as well. Did you pay the fine, or is that?
No, sir, I've not paid that yet either.
Okay. And was your original license in Tennessee or somewhere else?
My first license is in Tennessee.
Okay.
Then I moved to Kentucky and got a license there. That was back when economy had gone south. I was looking for a job. Current job here had slowed down considerably. Found a job in Kentucky
took that job and worked there for a few years.
All right. Let me just kind of open it to questions from the rest of the board members as we go. Jay?
Yeah, Mr. Futch, I appreciate your time today. You know, I was provided a copy of the consent order, to which I understand you did sign and agree to. And in review of it, the allegations were 10 in total, I believe, if I count them correctly, made by the Kentucky Board, which include misconduct, gross negligence, failure to gather and analyze evidence, another charge of misconduct, failure to hold original monumentation, failure to complete description, and on and on and on. Many of which are egregious and to the core of what I consider surveying, which is boundary. The fact that that happened across the state line, in my opinion, does not negate any responsibility toward your surveying efforts here in Tennessee. A license in Tennessee gives you all the responsibilities and privileges that it does in Kentucky. And obviously, there was a failure on your part, based on this consent agreement, to do so in Kentucky. And I can only make, in my opinion, again, the assumption that the way you survey in Kentucky would carry over into Tennessee or any other state that you may be licensed in. For that reason, I find it difficult to have a clean conscience and sleep at night when I'm responsible to the public of the state of Tennessee for the surveyors, myself and this board, knowing that there is a surveyor out there that conducts his business that way, his professional, licensed, regulated surveying business that way, as demonstrated and agreed to and signed by a consent decree in Kentucky. Can you explain to me, briefly, why I shouldn't believe that way in your surveying efforts in Tennessee? And explain it to the public here that's watching the same thing.
Okay. I had two options. One was to, three options. One is either hire an attorney or to dispute all their claims or do it on my own. And the other was to simply sign the decree and go on from there. I'd already let my license go back in Kentucky, had not renewed them, and I decided not to take the time to have to go up there, spend the time to go dispute everything they said, and have to fight it in front of the board. If I were continuing to survey there, I certainly would have. Part of what they said, which you touched on, was ignoring existing monuments. They did an investigation, a partial investigation. They did not investigate why the previous surveyor had placed monuments so far from where the deed called. And part of the reason for this survey was one neighbor had built an addition onto a house and was across the property line. Like I said, I was no longer practicing in Kentucky and decided not to go there to fight their decisions, and that's where we came up with. I signed the decree and went on from there.
So let me ask my question again. I don't know that I got an answer to it there. Convince me why you should continue to survey in Tennessee and continue to hold a license based on the previous actions of the consent order in Kentucky. Tell me why. Don't tell me about the details of the consent order. I've got all that right here on paper. That's not what I'm asking.
Very well, yes, sir. I've never had any disciplinary action in Tennessee. Never had any complaints in Tennessee. Everything I've done as I did it in Kentucky as well is by the surveying law. Try to do the best for my client, try to protect the client, try to do the best by clients on both sides, or the client and their adjoiners. go out of my way to try and do the very best job that I possibly can do.
I got to tell you, Mr. Foote, just to be blunt, that based on what I read in this consent decree with the 10 allegations that were signed and agreed to by both the board and yourself, I find that hard to believe, quite honestly. It's very difficult. There are issues in this consent decree that are just egregious to the profession. Absolutely egregious. I cannot, in good conscience, know that there are Tennessee licensed surveyors out there who survey this way, quite honestly. It's hard to swallow, quite honestly. And for that reason, I've got issue with the renewal here. So I'll let other members speak.
Let me just ask a question before I move on to Justin. How did the complaint actually come about? I mean, I read through this and you just mentioned that there was a dispute between the owners. Did one of the owners or the other, or I mean, and we have a report in here that says that you were never actually on the site, which, you know, troubles me a bit on something as complex as this. So how did the complaint come about, and do you agree with that you never actually met? In this situation, to me, it kind of calls out that the surveyor needed to be on site and talking to both sets of owners.
I was on site. I was not on site at the initial visit. Actually, I was on site. The job started as the client who called us wanted his boundary retraced and determined exactly where it was. He suspected that the adjoiner was across the property line. So sent a crew out, gathered information, even to the point of having to survey the adjoiners to prove that the common boundary line between them was in the same place. After the job was finished, approximately a year later, we were contacted by an attorney, and the job then was going to court. Then I went out and visited the site to be able to assure I had everything visually in my mind if I had to testify about the location of things. And after the court was over, after the decision by the judge was made, this next part is secondhand information. The adjoiner's attorney did not pursue in the timely fashion, and a certain amount of time went by and he was not able to pursue it. And then at that time, then he contacts the board complaining about my work.
All right.
But I did visit the site. I did not visit initially, but once we were contacted that it was going to court, I did visit the site.
Okay, so during the process of the survey, you didn't visit the site, that you visited the site once it became clear it was going to court? Is that?
Yes, sir.
Okay.
Correct.
Just,
The only thing I would throw in here is, you know, the kind of the biggest concern for me is as a board, we're looking at this situation and, you know, we've got clear evidence of a board making a decision, a ruling that was signed off and agreed by you, that you walked away from and did not comply with. So what gives us any indication that you would comply with this board should an issue come up? So, you know, from this board's ability to do what it's charged to do, that seems contrary to, you know, to that working out. So that's where I'm at.
I understand.
Kevin, anything?
Yeah, I would just ask, I'm the public member, Kevin Martin. I saw in the text here that at some point, I guess some previous surveys have been conducted, and I don't know if, did you, or did an employee of yours, did they miss the pins? Was there's some, it seems like there were two prior surveys from other surveyors that partially got missed or neglected, not included. Can you expound on that?
No, sir, they were shown the pins by the adjoiner that he claimed were his corners. Uh, That was part of the investigation that was never followed. They never investigated why the previous surveyor placed his corners. They were 18 to 20 feet out of place. And we're talking about 1 acre size lots. They never investigated as to why he had placed his so far out of place. And never investigated whether there was an attempted re-subdivision done to clear the house or gain extra land so that the house could be added on to. I can't explain why the other surveyor had placed those 2 pins out of place so far. I did disagree with them. That's why I placed my corners where I placed my corners.
Did you make a note of those 2 pins and any documentation suggesting that you know those were a concern and maybe that should be ironed out? Seems like just as a homeowner, I mean that's how I would feel about it. I'd like to know that, you know, I'd like to know everything, all that.
Right. No, sir, I didn't show those originally on my map. And in retrospect, I should have. I could not explain them in any way. And like I said, I did not use them. They did not match either property owner's deed.
Understood. I appreciate your answers for that.
Yes, sir.
You know, I appreciate the, latitude that the board has afforded, and, and one of the things that makes this particularly difficult, Mr. Futch, and this is Executive Director Kopchak, is we don't have jurisdiction in Kentucky, and so we can't relitigate those facts. But under Section C, you signed, as evidenced by the signature below, acknowledges Part A, I have read, understand, and admit to the foregoing as stated in paragraphs A and B. The facts are listed in A and B, and that's page 9 of the consent order. So at this point, we would be inclined to agree with the person making that statement and affirming that, and their signatures, at the last page, yours is included. So at that point, we're stuck with a fully executed consent order that you're not presently in compliant with.
Yeah, I agree. That's hard to get past of it. Just asked just a few questions here to see if there was somewhere we could go with it. I'm a big believer as part of the thing as a professional is you take personal responsibility regardless. And this doesn't speak very well of that, taking personal responsibility of it. But do you have any final comments to make?
No, sir.
Okay. Very well then. Recommendations, motions?
If I could ask the executive director, what are the options here in terms of his request for renewal here? What are the options that were allowed? Obviously, there would be approval, obviously, or there may be denial, but there may be some other options in terms of his license. What are those options available to us here?
Well, I'm gonna, as I make this statement, I may need some help from the board and from legal, but I'm gonna just go through that real quick. And then if I was to run into any areas that can be fully expounded, then I'll borrow from your expertise. But if you chose to deny his renewal, if that's a route that you went, not to say that that's what the board's going to do. I don't necessarily know that, but if the board chose to do that, then, because that's what you're asking, what are the options at that point? At that point, if he were to be in compliance with his Kentucky order, then that's no longer an issue at least that part of of the equation is not a part of the issue, then he could reapply and then reappear before the board with that reapplication after he's taken care of this. That's one option. Without a complaint here, that would be the extent of it. If there was a complaint here and he was an ex licensee, then you would, there's due process that could go all the way up to include suspension and revocation. But since he doesn't currently have a complaint with us, that wouldn't be the case. So it's either approve his application or deny it, and then, but you can caveat that with take care of the consent order in Kentucky and then reapply if you want that, or whatever other terms that you were to come to mind. Of course, within the scope as afforded by, we can't do, there's not, we can't, for applications, it's not disciplinary action, so you can't like add, sort of provisions, he either qualifies or does not, so you would be very limited in that regard. And then, without trying to anticipate what all that might be, I'll hear from the board, and then if we need to sort of sidebar counsel with our attorneys on that, we can do that as well, so.
Well, if I understand you correctly, it sounds like it's almost until he comes to some agreement with the Kentucky board where they redo the consent order to something that he can clear in somehow, that it pretty much sends us in a particular direction toward denial. Any thoughts from legal on that?
I mean, the only thing I could do is tell you what statute gives you the authority, and I can read that, but.
And I think Glenn did on that, so.
You know.
Any other?
So you have the authority for an approval or denial, and then, but you do have that, that issue with Kentucky that's looming there.
So if I were to make a motion here, it's for denial of the renewal application, is that correct?
Yes, sir.
All right, so moved.
Second.
All right, we have a motion and a second for denial. Any additional questions, thoughts? Then all in favor say aye.
Aye.
Opposed? All right.
All right.
Thank you.
And then, Mr. Futch, should you get that resolved in Kentucky, you can always reapply. And then I would certainly, where there's new information, if you have the same information, I suspect that you would you would probably very well run into the same result. But if there's new information, such as resolution of that outstanding issue there in Kentucky, and you would like to reappear before the board with the reapplication, then I would certainly encourage you to do that.
Okay,
All right, thank you, sir.
thank you.
If I could just make a general comment real quick, this is not related to Mr. Futch at all. Many of us, especially where I'm located in Memphis, we're strategically located on the border of numerous states, Mississippi, Arkansas. Most surveyors in the Memphis area are licensed in multiple states because of the geography. I'm sure the same goes with Knoxville and probably Nashville here too. But the point is that I'm trying to make here is that when you're licensed in multiple states, not only the responsibility of those individual states lie upon the burden of the surveyor there, but also if you have disciplinary action in a state and you're licensed in multiple states, most states, and I believe this board is included, requires you to report that disciplinary action to those other boards as well. And oftentimes that's done through the conduit of the NCAAS record, but not always. And I believe it is on the registrant themselves to notify every other board you're licensed in. Just in general, just a heads up that goes for others that are licensed in multiple states, myself included, it carries over. It carries over to other states as well. So just be aware of that. If you think you can afford to lose a license because I've got others in other states and I'll be able to carry that, not necessarily. So just Off the
And,
soapbox.
When just additional layer is that, let's report it to NCAAS as well. So I've had situations and heard of other situations in jurisdictions where, it went unreported, not in this case, but in other cases. In those cases, then that becomes another charge, you know, because becomes a misrepresentation as well on your application. So anyway, thanks, sir. Chair, are you ready for the next item?
Yes, which is the election of officers, I do believe.
All right. Well, let me just give you the statute that brings us to that. You know, not every board annually does that, but according to our statute, we must. So that's why we do that. So you're probably thinking, man, we just got sort of seated and then we're shuffling the chairs. You don't. So it's up to you, but TCA 6218-106A4 says the board shall elect annually from its membership a chair and a vice chair. The current officers, for those that may be listening, are current chairs Gary Clark, Vice Chair Jay Kaufman. Is there a slate of officers by way of nomination that anyone would like to present?
Go ahead and nominate Gary Clark as chairman, Justin Raines as vice chairman.
All right, just need a second in that regard, and then discussion before we vote if we need to.
A second.
Okay.
And then the question, Justin, are you happy with me? You're willing to be vice president, I guess.
I'm very willing and happy for you to be.
I am willing to continue to serve another session as chair. So we have the nomination. I guess it's just a matter of the vote. All in favor of that slate, say aye.
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 Opposed? Very well. Congratulations, Justin. And then back into the director's report.
All right, thank you, sir. Okay. We're gonna hit we'll do the budget first. This is just informational purposes only. You can always, with us, it's because we're on the same renewal cycle. It's pretty clear when that is. You just look at our budget, you know, and then that becomes abundantly clear. You see those 3 months where we're in surplus, and then the rest of it we run in red. That's pretty common. At the last meeting, we reviewed the current fiscal year through December. So instead of rehashing that, I'm primarily focused on January, February, and March. The big item that I saw, everything else seemed to be trending like it's like it should. I didn't see any variance historically. Some of that is mapped below. There's the historical trends. You can see some below there as well. Just that small print near the bottom, but. Also, I've got the expense reports. I get the ledger, so I get a chance to look at that too. So there was one item that jumped out at me, and you probably saw it too. The other expenditures for the month of January, the big bump there, you'll see we were tracking it like 2,000 and then 10,000, and then we're back to 1,400, 1,100. You know, it's that gray, that right where it says Surveyor expenses. So you've got Edison expenses. Let's see, 1, 2, 3, 4. Rows down January from expenses, that 10,000 hit right there. That was nothing outside of the ordinary. That was NCAAS membership dues. Yeah. Since that's January, we you know, like A&E saw that, and you know, NCARB and everyone, you know, January they come, if that's their cycle, we're going to make our payments there. So you'll see that again next year, January, February. So that's all I saw. If there's anything else that you saw, but looks like we're still in surplus during this this renewal cycle of $181,175. All right. Unless there's any comments, and of course you're welcome to direct those to me, just direct as well as if you ever see those things and want to have a discussion with me, and you have, I'm fine to do that, and of course we can do it here as well. But sometimes you just want more clarity on a particular line item, then just shoot me an email as well, and then I'm happy to answer those as they come up. Okay, looks like the NCAAS annual meeting is scheduled in Chicago, Illinois from August 14th through 17th. So we'll just need to make a motion for those that would be going and take it from there.
I guess my question on that is, I've got on my calendar that the board meeting is on the 18th.
Yeah, well, obviously, we're not gonna, have you guys same day when you get off the airport, come straight over to a meeting, you know, but, so we'll shuffle that around. That won't be a problem. Whatever we need to do, we'll take care of that. I thought we had moved that, but if not, we'll make the announcement at the next board meeting. But I've made a note of it, and then I'll let you guys
Okay.
know what that
As I
is.
remember, I think we moved it from the week after to that.
August 22nd then. So August 22nd is the date. I thought so. Thank you, Heidi. So, and I'll check the website to make sure it's still there. I believe we had that discussion when we first put the schedule down. That's probably, you've got the memory of an elephant, Gary.
Okay.
And so that's probably where you're getting that from. But yeah, August 22nd then. And I'll check to make sure our website says that as well.
Okay.
Thank you, Heidi.
Do we need a roster of who'll be attending?
Yes, sir, please.
So I plan on it.
Without that, I plan on it.
Yeah, I'm going.
Okay.
Good. All right.
Sounds good. And then if you guys, at any point, roll out, then we'll send Mr. Martin as well. But we'll just need a motion in that regard.
So moved.
Second.
All in favor, say aye, please.
Aye.
Very well.
Okay, just making my little, I want to make sure. Okay, perfect. Thank you so much. So, boy, we've got everyone working today. So Erica just came through. She said that it's on the website as well. So we're good. It's the 22nd. Thank you. All right, Southern Zone meeting update. So Jay Kaufman, he chaired the nominations committee at the NCAAS Southern Zone. And Team Lingerfeld gave the surveying and mapping sciences licensure task force update and led the land surveyor forum breakout session. So we put Tim to work, and you know, we didn't even send him, but we put him to work. So it was good to see him there too as well. You know, and then of course I sent you Tim's letter of support for their recommendations on the task force he was looking at. You know, I'm not sure that the board would be able to issue an official letter to NCS on state letterhead, as I'm not sure we have enough information yet to support a definitive conclusion from the board without specific examples. Since we don't have access to the NCAAS exam, we're sort of, you know, taking his word for it, which is, you know, he's credible, obviously, but for us to make an official position, we would have to see the raw data. And so, yeah, and we're probably not gonna get to see that. So I don't know that we can go that route, but, you know, I know Gary and I, we talked about the letter. You all saw that. It was some time ago. I mean, you know, we've all slept since then. But you know, it was just basically, you know, Tim had a couple recommendations for that portion of it. Gary, did you want to expand on it or not? Or?
Well, of course, Jay's probably been through this before, but so much of it was about the added module for the surveying that would add mapping as a separate module to it. And seemed to be a lot of angst that it keeps getting agreed that needs to be added into it and then gets pulled by a floor vote at the last minute. And that's pretty much everybody was complaining that we seem to be just spinning our wheels and not really moving forward with that. That's about the gist of it on it. I mean, again, it seemed like everybody was for it, but it can't seem to get it over the finish line for some reason.
Yeah, and you know, letters are helpful, but that's best demonstrated in a vote.
Yeah.
You know, when a committee brings a motion to the floor, then the boards get to render a vote. If they could bring that in the form of a resolution for the hearing of the entire association and all those respective boards, then I think that would do more to move that forward and out of committee.
As I recall, that's what happened when it came to a vote at the previous meeting. Questions came up and it was either pulled or deferred or voted down. Yeah. And that's where most of the angst was. Yeah, right. So I think they'll probably have to go back to drawing board and keep hammering it out and make their case and then get it to the floor. And I appreciate some you know, the boards you know, oftentimes can write those letters, but at the end of the day, it's that committee work, you know, and then moving it out of there to the floor is where it gets done. So and sometimes that's an uphill climb, and I don't know without that data though we're gonna be able to make any definitive sort of conclusions. So
I don't know that there's necessarily any action for us to take, but for just sake of awareness, and, you know, and for sake of discussion, and plus out of respect for Mr. Lingerfeld's work. We all appreciate what he's doing up there. And can't think of anyone better really to be doing that work, so thankful for that. If you're good with it, then, Gary, did you want to, or anybody else that was in attendance, and Mr. Raines, you can fill in as well, if there's anything of note that you wanted to touch on before we move to the next item?
That was everything I had on top.
Okay, thank you.
I mean, it's-
Mr. Raines, anything else you want to add? Okay.
No, I think it's been covered well. I mean, that was the issue of the day. Yeah, it's a big group, so it's, the votes are important. But nope.
Thank you. All right, well then, in that regard, then I think we can move to the emeritus nomination, and it kind of dovetails to what we're talking about. We're talking about Tim's work, and real quick, you know, he served on the NCWS exam committee in the past. Although NCWS voting privilege would be reserved for current gubernatorial appointees in attendance, Tim would need to be recognized by the board as emeritus member to continue his work on future committees without interruption and lend his expertise both in committee and on the floor at NCWS annual meeting, should that be necessary. So it's just helpful. It's practical, but also it's an acknowledgement for what he's already doing. I mean, he's already part of the team. He's already doing that work, and so you know, if it pleases the board, I'd like to, if somebody would like to make a nomination in that regard, we can submit it for final board of director approval. They're meeting on the 19th, and so, you know, all we would need if the board was to take that action today would be to get our chair to sign it. So Gary, you would sign it, and then I would forward it to them today, and then have that in their hands in time for them to make a decision without delay. They meet, I think, quarterly, so it's actually very timely.
I think it would add to some of the continuity to have Tim continue in his efforts.
Yeah, and it certainly affords him some advantages within the NCWS organization as having the emeritus status. And I mean, I can't think of another person that would be more deserving of this, you know, short of sitting on a board seat, which obviously has quite the lengthy history of doing that. He was pretty much responsible for bringing this board back into the fold of the NCWS organization. For many years, there was empty seats at the meetings. The surveying board just did not represent. And once Tim came on here, he recognized the importance of it, and certainly shared it and spread it amongst the board members during his tenure here, and has continued, even without his presence here on the board currently, he has continued to be actively involved in a very positive way. And I can't think of anyone else that I could recommend stronger for the emeritus status toward the NCWS organization. So I would like to make that in a form of a motion.
We have a motion, we have a second.
Second.
All in favor, say aye.
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 All right, thank you, sir. And then Gary, I'll get that signature from you before you leave, and then we'll get that up to him. Yep. And just as a side note too, as a practice, they request a term end date. And so we typically do about 3 or 4 years. So he's got, you know, we're gonna do 3 years on it, just because it wouldn't just be open-ended forever, you know. So, and then plus it allows some structure for NCWS as well. So, okay, yep, thank you. All right, looks like we're ready for a public comment period related to items on the agenda. So I'm just gonna take a step up here for a second, and then to see if we have anyone signed in either here or the chat box, and pause for that.
Very well.
All right, we have some folks signed in. The Campbells, Eddie and Labriska, was that for the education report, or did you all have any comments that you had to make? Okay, yeah, no, that's good. No, we want to record everyone's visit, of course. You spoke as well, did you? Okay. Did you have anyone there? No. Okay. Seeing none, I think then we're ready for the next portion on our agenda.
Very well. Then we want to go ahead and just push on and jump into the legal report?
Well, we do have Jimmy Cleveland. Did you want to speak? You spoke earlier.
Yes, sir. I was just curious as to whether any approvals for the TAPS classes were granted. I missed that education report.
They were added. Phil took care of you. He got you right underneath the wire, even though even though it was sort of a last-minute entry, he still got it on the report, and, just like his typical style, he got it done, so we are good.
Thank you so much. I really appreciate
Yes,
that.
sir. Thank you. All right. Looks like we're ready for that legal report then.
All right.
Okay. Okay, so I've just got two on the legal report today. The first one is 2023065801. Complainant is a licensed surveyor and respondent is unlicensed. Complainant received a phone call on December 5th, 2023 about a survey that had their seal and electronic signature on it. Complainant could not recall working on the survey, even though it had only been a couple of months since it had been signed and dated. Complainant then confirmed that they had never surveyed that tract of land related to the survey and realized respondent had fraudulently imposed their credentials on the documents and listed complainant as the survey and responsible charge without complainant's knowledge. Complainant approached respondent about the survey and respondent admitted they forged complainant's credentials on the survey and documents. Complainant then further alleges that the firm respondent works for does not have a licensed surveyor on staff, but continues to offer land surveying services to the public. And from what I can tell, respondent's employer is an engineering firm. They don't have a website, or anything, but from what I could tell on LinkedIn, it seems they do engineering. Respondent does admit that they fraudulently placed complainant's stamp and seal on a drawing that respondent had not yet sent to them for review. Respondent states they had been working with complainant for the last 5 months and would provide complainant with data and drawings to review and then sign. Respondent states that they did not get this drawing to complainant in time and was under pressure from their client to get the survey done. So they made, quote, a terrible mistake and added the complainant's seal and signature without their permission for review. So my recommendation as it relates to the respondent is to issue the maximum allowable civil penalty of $1,000 for each of the following violations. So for $1,000 for engaging in unlicensed activity by completing survey work and creating a plat with a stamp and a seal for a client. $1,000 for misconduct in the practice of land surveying by fraudulently stamping a plat with a seal of a surveyor without their knowledge. $1,000 for affixing a seal and stamp to a document that was not prepared by that surveyor. $1,000 for fraudulently certifying that a survey and the work thereon was done by the registrant or under the responsible charge of that registrant. So that would add up to a $4,000 civil penalty. And then I also thought we should discuss possibly opening a complaint to look further into the respondent's employer to see if they do have a responsible charge. And if not, how many surveys they've done without it. And I really would leave it up to your discretion how far you would want us to investigate that, if you do at all. And then also discuss the possibility the complainant might be in violation here for working on surveys or sealing surveys in the past without meeting the requirements of Rule 0820-04-0.08, which kind of defines what responsible charge would mean, doing a survey under responsible charge. So it seems there's 4 requirements for that. And the one I'm most concerned with is that a client has to request the preparation of a survey directly to the surveyor themselves or a member or employee of their firm. So I know that complainant doesn't work for respondent's firm. So I don't know how that could possibly be met. So that concludes my recommendation. I would love to hear from the board on what they think about those things.
Sure. A little bizarre. I guess the first question I have though is, did the company that the respondent worked for have a registered surveyor at one time that they just lost?
I don't know, because we don't have a complaint against them, and I didn't want to open one without discussing that first, because it's gonna be pretty, it's gonna be intrusive, and it's not like I can just look on their website. We're gonna have to have an investigation.
Sure. I mean, to me, that's kind of key in this, other than the ruling toward the respondent, in my mind, is pretty correct going down the line. As far as the complainant and the company, I could see this happen several different ways. I mean, I have calls from folks all the time mentioning that the company lost their licensed surveyor, and they're trying to figure out how to not have to, lay off their entire staff until they get somebody back in there. It's a problem with the smaller companies and sole proprietors. They just have the one surveyor. I've actually, long before I came on the board, had gotten calls by companies that the guy was fixing to retire and he hadn't brought anybody up and was looking for some way to have his people taken care of. Yeah. And so there are some fairly benign reasons why this could be happening if they had unexpectedly lost the only surveyor they had, and perhaps the complainant was just kind of filling in on a temporary basis to keep it together until they got somebody on board. But I have to think if that there's a big enough of a problem of miscommunication here that the licensed surveyor himself would turn in a complaint, which is essentially waving his hands and say, please come and look at me. I may have done something wrong here. That it must be something fairly egregious right here. So that's the biggest question I had. I mean, I could kind of go down a more benevolent path if this was the case, where these were just folks working together trying to keep everybody from losing their job and actively working to resolving the situation with hiring a full-time surveyor in there. But the fact that they went ahead and took a client without first notifying the licensed surveyor involved doesn't land very well.
And I will say the respondent, gets a copy of this complaint, and the respondent addressed all of the allegations, but did not address that allegation, which makes me assume that it's probably
that one's
true.
Fairly major to me. That kind of stands out, that you didn't have enough control to actually be aware that a job was going on.
Yeah.
And it may be that the complainant felt that the only way that he could get it serious to everybody was to file an actual complaint, which doesn't lend me to believe that he had much responsible charge to the whole thing anyway, if that was his only recourse to it.
I know the last meeting we had a complaint where we kind of discussed whether an engineering firm was offering surveying services to the public. And I'm wondering if this firm may think they're not, because of the same reason, maybe it's not clear to them and they don't think they need one, and they're just using a consultant.
Well, of course,
again, that's just something
Well, part of what's going to happen here, I mean, even if we take no action against the company, it's likely the company is going to bear the brunt of the fines for the respondent, although I think it's good to keep him personally involved like that, because it's very clear in the statute that the surveyor is the one with ultimate responsibility, or the pretend surveyor in this case, and that's a bit of a problem. I'm not sure how far to go on that. I hate to open up a complaint on the company, but there's a few questions there I think need to be answered.
I mean, we could always keep this one open and not make a decision until the next meeting, and I can further inquire with the respondent and have him,
I guess
answer some
that's
more
what I'm worried
questions.
about. I hate to make a decision and close our options on this, because if it was a fairly benign agreement from everybody that they just trying to keep folks employed and remedy the situation, had something in play, and they just did it badly, is one thing. The questions we have right here kind of lead me to believe, that they felt like they should be able to do surveying without the surveyor.
Yeah.
And that bothers me, so.
I mean, if we opened a complaint against the firm and we found nothing, it wouldn't harm them. So, and If we kept this one open and I had the respondent answer those questions and we found violations, we would still have to open a complaint against the firm because I couldn't hold the respondent responsible for that.
Right.
So there's those considerations.
Yeah, okay, I've wandered around for a moment. Anything?
Oh, yeah. Oh, there's something here. All right, I got green blinky light. Green blinky light. That's all I get. Me to, okay. Okay, oh yeah, this is a good one here. Good work, by the way.
Thank you.
Okay, so obviously we have kind of three different issues here. My first question, on the respondent, who we're questioning a civil penalty of $4,000 towards. Do I have that correct?
Yes.
Okay. Is that the individual or is that to the company?
No, that's the individual.
To the individual?
Yes.
Why is that not the company? Is not the individual representing the company in his capacity there?
Well, the complaint was opened up against the individual.
Okay,
And the individual's taking personal responsibility
okay,
for making this mistake.
okay.
And in my opinion,
I mean, he's acting under the authority of the company that he's working for.
yeah, I
imagine,
mean,
but-
I guess in my opinion, in our definitions, a person can be a firm or a person can
Certain-
be a person. So it's how we want to approach this. This is how it
I
was
prefer-
filed as against the person.
Right.
So, but I also question if the firm is having some other issues separately that,
Okay,
Need to
okay,
be
so
looked
just for
but
clarification,
here, this is the person only.
The individual
Working
person.
for the
Okay.
company. As from what I can tell, this person is a project manager in an engineering capacity.
right, and it sounds like he's taken responsibility for it.
Absolutely. Oh, there's no
as the
question about
individual.
that.
Okay, all right, I'm good.
No excuses, nothing.
Okay, so I'm on board with all four of those violations there in the recommendation. Okay, second entity is the company itself, practicing unlicensed activity. I think by far, absolutely. Again, that individual is acting and performing work services as a company and is obviously taking the assumption that they've got a surveyor down the road that'll handle the work for them.
Right.
Now, you mentioned there is no website, we may not be able to find a website, a business card, whatever that says land surveying, but if they're offering engineering services and they're saying, oh yeah, as a part of that, we can get a survey done for you, blah, blah, blah type thing, which is typical in an engineering environment. They know a survey is required, we'll get the survey handled. Now, it wasn't handled correctly though. I think there's still the implication that they are offering the service. So I think it is definitely worth filing the complaint. I think
I
the board needs
agree.
to file the complaint. And if nothing comes of it, nothing comes of it. No harm, no foul. But there is definitely smoke here. Thick
Right.
smoke. Thick smoke. Okay. Lastly, against the complainant. No, yes. Who am I? The
Yeah,
registrant.
I
say
just wanted to
registrant.
discuss that. If you wanted us to open a complaint against the complainant.
Okay,
It's up to you.
Boy, I'll tell you, you're damned if you do, you're damned if you don't. What I don't want to do is discourage
That's how I feel.
future complaints here. I wouldn't want to be a registrant and see something like this going on, an obvious and egregious violation. And to be hesitant to file that complaint. I just don't want that to happen. But there are some issues here. And my biggest issue that came to mind was there seems to be no control over his stamp. It's not said directly here, but I can certainly read into it that this engineering firm over here apparently either has a stamp or has a copy of a stamp and is willing to stamp and sign, and the surveyor independently is not even aware of it. So he has no control over his stamp. Good gosh. Obviously, he's aware of the business relationship here going on. Y'all do surveys, just let me know about it, and when you get it done, bring it to me, I'll review and good, That is not direct control. That is not
Right.
direct supervision. No.
Well, it bothers
No.
me that the complainant didn't mention that in their complaint. Like, if I just read the complaint, it sounds like somebody just randomly chose you and stole your stamp. And then I find out from the respondent that you're working with
Not the
them.
case, yeah. That
You
is
know?
not the case. It sounds to me like what's missing here, what would make me feel better is if there was a contractual agreement in the middle here where the engineering firm contractually hires survey firm to, perform services and et cetera. But it sounds kind of like a, hey, just bring it to me when you got it and
I'll look at
we'll
it.
work it out type. That,
Right.
no. So,
Let me interject a question there. So did I hear you correctly that the complainant didn't volunteer the information that he had been working for
No.
with the company? Okay.
so I'm open to debate here on that third one, but definitely, I definitely agree with your recommendation on the first. I think the board should file a complaint against the company for unlicensed activity, and I certainly want to hear the opinion of the other board members here on that third one, because I just don't want to create hesitation for people to file complaints. And it's a difficult situation there.
I'm kind of in the same place that Jay is here, and the thing that really jumps out to me is the control of the stamp, right? So what I would be curious to know is, has the process been in the past that once he gives the okay, they sign and seal it for him and send it out the door? Or is he, typically doing that himself, and this person stole it from him?
Right.
That's what, that's a big difference, because if in the past, this person has signed and sealed it with permission from the licensee, that's kind of a different light. And, I heard you say that he took full responsibility and didn't make any excuse, but I would like to know if that has been the case in the past, because, an argument could be made that that was the normal course.
Right.
And he just, skipped a step, got in a hurry. Which is not good, not okay, and it still bears some responsibility. But that control of the stamp is a critical thing here. That's.
Is there a way that someone who might have, let's say the complainant did review a survey in the past and gave permission and stamped it, can you do that electronically?
Not legally, in my opinion.
Okay, because I'm just wondering if he's got a copy of it, because the complainant used the word superimposed, if that's something that they can just do on the computer.
You can make it look that way,
That's
certainly.
that's what it sounds like the complainant is alleging. He didn't even give me a copy of it. So the complainant used the word, it looks like if you had a trained eye to a seal and a stamp, if you looked at this survey plat, it looks superimposed and fictitious. Though that's their words. So I'm just wondering,
No,
can anybody prevent that?
I think on the complainant, it was more that somebody called him about the survey and he didn't remember ever doing it.
Right.
So that and then when he looked at it, he realized he had never done it. So
Right.
at that point, it's not really needing to recognize it as a fake stamp. It's just.
No, I
didn't
just
do the
meant the
survey.
control,
Yeah.
I don't think that he's lost the physical stamp, or I just
Yeah.
was talking about the
Well,
ability.
with the technology we have here, skilled draftsmen can forge anything.
So I guess my point is could that happen to anybody as far as if you're worried about control?
Yeah, it certainly could. Yeah, absolutely.
Okay.
My issue there is, again, the engineering firm over here may not have the physical stamp itself. May
That
just be
doesn't
doing
sound
a
right.
CAD insertion of a block of some sort. It's the stamp and maybe a scan of his signature and superimpose it on top of that. But where I have issue with is the fact that it sounds like this has just been kind of an ongoing thing.
Right.
And
Right.
finally he got caught one time, hey, you didn't tell me, and I'm upset about it. But by being an ongoing thing, that surveyor has complied with it up to this point, saying it's okay.
Right.
So he didn't have control of his personal stamp for a lengthy time until one time he got a little upset about, somebody using it without being notified ahead of time. So, I may not be open to really pulling, disciplinary action against the surveyor, but at a minimum, a letter of warning or
Well,
something.
that's what I was thinking.
Something has to go here.
Just kind of a letter reminding the complainant of the requirements of being able to put your seal and stamp on a survey when you're just consulting. And
Absolutely,
Well,
absolutely.
I agree with Jay that I hate to, there's something commendable here that he at least had the guts to, because he had to know that when he put in his complaint that he was in jeopardy. I think at the very least, we have to confirm to him, yes, you are in jeopardy.
Yeah.
And he needs to feel like he's in jeopardy. But Kevin, what's your thoughts?
I pretty much agree with what you guys have said. Sometimes it comes down to, who's telling the truth and what what was behind what happened. I guess the question one of the questions is, right, was this normal order of business where the land surveyor may have said, you guys know how to survey, and I'll look at it when it's, do it, and I'll look at it and sign off on it. I mean, that's the potential, right? There is that potential. Yeah, I feel like some sort of letter at minimum, would be required. I agree with the other penalties.
Yeah, there is that potential. There is also a potential that he went into it with the correct idea and was helping them out and was meaning to have.
Yeah.
And the company had in their mind that they didn't really need him anyway. So that's where I think we have to do a complaint on
Yeah.
the company and investigate that further, see what's going on.
I would agree with that.
My thoughts on the complainant is that at the very least, a letter of instruction kind of supporting his feeling that he had done something wrong. But I don't know, maybe as far as having a complaint and looking into it a little further. In any case, are we to a point of making a motion or any further discussion or?
Yeah, I'll go ahead and make the motion to authorize a civil penalty of $4,000 for a series of violations as listed towards the respondent. Make sure I get that right. I'm going to leave that as a motion right there and then address the others separately.
Okay, so we have a motion for the fines to be levied against the respondent and reserving to further discussion the other two possibilities. Do we have a second?
I second.
All in favor? Say aye.
Aye.
Aye. All right,
Aye? Sorry.
okay.
I'd like to follow that with a second motion that the board authorize and open a complaint against the respondent's employer for possible unlicensed activity and operating without a licensed land surveyor in responsible charge and other findings as may be found from research.
Second.
We have a motion and a second. All in favor, say aye.
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 Was the motion clear enough?
Yes.
I know we talked for a while.
Yes, that's good.
And then that leaves the second recommendation that she made, of some kind of action with the complainant himself.
I would make a motion for this board to authorize and issue a letter of warning towards the complainant. Is that right? The complainant. For lack of responsible charge.
Erica's going to straighten me out if I mess it up and completely butcher it, which I've been known to do before. But
I need to stop anything since I put a motion out?
maybe not.
Withdraw the motion.
Okay. It's, so letter of warning, just as a basis, is disciplinary action. Letter of instruction is not. If you wanted to do a letter of warning, which is fine, you could do that, then in that case, you would open the complaint, because we don't have a complaint before us yet, then ask for the letter of warning, and then we would just open it and close it and send the letter of warning, but it would be disciplinary action. So it's just a process thing. It's not the end of the world. I mean, we could do it. It's just, that's how it would work. So, so yeah, if you wanted to, you based on hearing that, you might have said, well, I wanted disciplinary action. So yeah, letter of warning. Well, if that's the case, then we've just amended to say open the complaint and then issue a letter of warning. But if you're like, no, I didn't really want to do disciplinary action, but I did want him to be instructed, then a letter of instruction would be all that it would take. No complaint necessary. So that's up to you.
That's where I was going.
Okay.
Can we,
I guess the question is, you're saying if we could open a complaint and then close it with right here, and there wouldn't be any further investigation or.
If you did a letter of
effort?
warning, because that's disciplinary action. If you're doing a
Yeah.
letter of instruction, which is not disciplinary action, then you can send a letter of instruction to anybody without a complaint. You can just send a letter of instruction. You know, you can say, hey, look, that's a letter from the board say about referencing this matter, of course. Hey, there was a complaint that you submitted or that you entered, and then here's where, the criteria that we'd like you to consider as a result of our discussion.
Well, and that magic question that most of the boards ask when you go for renewal, say if you had anything happen, does the instruction and warning, both of those would be something they'd need to,
Not the letter of instruction, letter of warning would state, because, and there was some discussion about that at NCWS during different jurisdictions. There's folks that get letter of warnings and they're thinking, well, I didn't get a fine or, CE or additional education. I'm good here, but they don't understand that letter of warning is discipline. And so there was some discussion about making sure that's front and center on the letter when you receive it. And so it starts with, this is disciplinary action. And we do that in our letters as well when we send that letter of warning, so they know to report that this is disciplinary action, and it's to be considered and treated as such if it's a letter of warning. And so that's why we make the distinction.
all right, and one last question. If we went with the letter of instruction instead of the letter of warning, but then once we did the investigation on the company, additional information came up that we thought warranted revisiting it with the complainant.
Yeah, because there was no complaint, you could open up a complaint and then escalate that. The letter of instruction would not stop you from doing that.
Okay, no further questions.
But my concern with the open letter of warning close is, has the complainant had an opportunity to respond directly to this?
Sorry, can you repeat that?
Well, no, we're kind of discussing, from the standpoint of the issues we have with the complainant, whether or not we could open a complaint, issue a letter of warning, and close the complaint right now. But he hasn't had a chance, or he or she
It would be
hasn't
subject to
had-
that response, of course. So open, close, just a procedural thing, but we would go through the process, which would require that. And if there was new information, then our counsel would bring that to you as well.
Right, and if no new information, we would just issue the letter of warning once we got the response. If there was new information at the next board meeting, it would be on the legal report.
Okay, so actually, he has the opportunity to respond, in which case we might not send the letter of warning, and then he does not have something on his record that he has to report to the NCWS. So.
Right.
Okay, but it is still a higher level of jeopardy. And
So we would not be issuing the letter at this point. I'm getting confused.
That would be up to Jay Kaufman. He was the one that was, it's up to the board, but there was some.
Well, I guess to clarify, Justin's saying is, even if we adopt the motion, the process is you open a complaint, he has an opportunity to at least respond to it, and you might not send the warning without coming back to us first.
Right, I think through all this discussion, I think it might be best if we open a complaint for me to just bring it back to you at the next legal report with whatever information I have, and you make the decision then. Or we just do a letter of instruction in connection with this complaint that would go to the complainant, and there would be no complaint opened. Those are the options.
Nobody wants me to talk. I don't blame you. All right, so with that discussion, good discussion there, I would like to make a new motion for the letter of instruction. I do think that's the proper course here. Again, well, let me finish the motion. Letter of instruction to the complainant in regard to responsible charge and in regard to control of his physical stamp or digital copy thereof, his stamp in general.
Second.
Any further discussion on that? All right, we have a motion and a second to issue a letter of instruction. All in favor, say aye.
Aye.
Aye. All right.
Yeah, I do think, that's off the board there. I do think it's important that as the investigation goes on into the company, there will be more details that come to light, I feel, which could open further paths for disciplinary actions towards the complainant. It is possible.
Yeah.
But we
And
just
I-
don't see it, don't have it right now. And again, I want to commend him for coming forward.
And I agree with Jay that I don't want to squash him because he did come forward, and he may have, and I know he has to believe that he's going to take some heat because of coming forward, because he has some culpability here. But we'll see what your next investigation does with the company reveals and take it from there. Thank you.
Okay, and that takes us to the second and last complaint on our legal report. It's 2024-013-941. Complainant entered into a real estate agreement with his relative, who I will refer to as the buyer, to convey a portion of their land to the buyer for a cheap price. Complainant and the buyer closed on the sale of land in January 2024. Complainant alleges the survey does not match up with what they expected. Complainant alleges they have been the victim of a real estate scam because respondent and the buyer are giving complainant inaccurate information. An expert review was conducted. The expert first notes that respondent was hired by the buyer, not by the complainant. The expert explains that a line was agreed upon between complainant and the buyer to divide the property, and respondent conducted boundary work to locate the proposed subdivision line. When respondent returned to set the final corners along the new lines, they were in a different location than complainant expected. Complainant then questioned the field crew and obtained respondent's phone number at that time. Complainant further takes issue that one of the members of the field crew is related to the buyer. Respondent confirms that they provided a preliminary subdivision exhibit depicting the initial agreed-upon line between complainant and the buyer. After beginning the subdivision process with the county, it was realized that the proposed new lot did not meet lot size requirements per zoning regulations. In a phone conversation with the buyer, respondent described the issue and the solution of moving the southerly line deeper into the complainant's property to achieve the correct minimum acreage, while also adhering to setback regulations. In this conversation, the buyer expressed their intention to relay the information to the complainant, as complainant would ultimately have to sign the plat. Respondent described the plat signing process and advised that the buyer obtained complainant's signature before recording. Respondent advised that complainant never contacted them, but respondent did receive calls from the county sheriff's deputy and complainant's attorney. Respondent advised that one of the field crew members was the cousin of the buyer's nephew and that it in no way would have had any bearing on the outcome of the survey work performed. Respondent also provided exhibits as staked reports for the corner set and additional zoning information from the county, so that was included in what the expert reviewed. The expert found no evidence of any violations and concluded the signed conveyances and plat clearly depict the lines as they relate to known and apparent landmarks on the property at issue. The expert, their opinion is that the communication between the buyer and complainant is likely the root cause of this complaint. So based on that, my recommendation is dismissal.
Thank you. As usual, very clear. Yes, I have a hard time thinking the respondent has any culpability here. Any thoughts from the rest?
Hearing none, make a motion for dismissal.
A second.
We have a motion and a second for dismissal. All in favor, say aye.
Aye.
Approved.
Thank you. That concludes the legal report.
Which brings us down to new business. I guess, we have anything from the floor? Any? I have a question myself in regarding to the, I assume y'all got to read the new statute that went through that TAPS had sponsored. And what I'd heard from was that one of the results of that was that the PS exam is now decoupled from the board and that anyone can take it whenever they're ready. Is that how that came out? Because we, speaking with the folks who drafted it, they didn't think that's what they were trying to do.
Yeah, no, that is correct. That is in fact what it did, yes.
Well, I'll chime in on that just a little bit. Agreed. I wasn't aware that that was a byproduct of this legislation introduced by TAPS. But quite honestly, I'm in favor of it. I know the NCAAS organization pushes that, strives that. It's been a topic of this board for a while. But it's always been one of those things down the road, like when we get to it, we'll get to it. So I think if it happened by accident, I think it was a good accident. And I encourage, if you're ready to take the exam, but keep in mind you still have the three-legged stool of, examination, experience, and education. And all three of those have got to be checked. We just kind of, they used to be in a set order, but now we've just kind of said, hey, all three, any three, take them when you're ready. But it doesn't negate the educational requirements, the experience requirements, et cetera, et cetera. So
Right.
I don't have any issue with that.
And to be clear, I don't have any complaint with that. I was just surprised that was the outcome because I didn't read it that way myself on that. But we do get asked about how it works on that. And so I say, what my understanding is, and please somebody correct me if I'm wrong, is that now anybody with a high school diploma and the money to send in to the NCAAS can take the FS, the TS, and the PS exam at their convenience.
That's correct.
And the board, they don't have to consult with the board at all on any of that. But it just becomes something that goes in on their application that they have already taken those.
That's correct.
Okay.
And one byproduct of that is a positive is they can just come to us when they're ready. They're not having to sort of screen eligibility, prior in advance. So you're not touching it, or the folks aren't touching it twice or holding an application for periods of time. Like when they're ready, they just present all their materials to us, and if everything checks out, it's out the door, they're licensed. So there is a benefit to it, and just as a footnote, that's a good reason or sort of a case for. There's always sometimes unintended consequences anytime we do a red line ever, and when I say we do a red line, we don't necessarily do red lines, but we'll offer in departmental bills as offerings for that the boards want something, and we'll sort of send that up and say, hey, have you considered? The boards have discussed this, and some get adopted, some don't, most don't. I mean, it's because typically that's a work for. It has to be picked up by a sponsor, and that's better with the constituency, the associations themselves, or the general public. We don't. But my point being is, I've done red lines, and so when you do those red lines, and those have to go through. Typically, they start in legal, But I've looked at some, and been a part of that process, and they. It has to go through lots of different checks and balances because of that. There's sometimes unintended consequences that you don't even foresee. When you're moving things around out of different subsections and other subsections, and you don't realize that you may sort of take a frame, or there may be presuppositions that no longer exist because of that movement, and so and that's so I just say that's a before they get sponsored, we don't mind taking a look at it and helping with some of that, and not that, but obviously we don't. That's not necessary, but if somebody ever wanted us to take a look at it, we'd be happy to do that too. Future or just have those type of questions to ask, like, does it do this or do that? Based on and we can run that up the flagpole, as well.
Well, and like I said, I have no opposition to it particularly, or not even suggestion that it be revised and resubmitted onto it. It's, like Jay said, it's something that has been discussed at NCAAS, and it has support. I think knowing that fact, though, that we need, as surveyors, we need to make clear to all of us surveyors that makes it where, it I guess the blunt way of even before I was on the board, I had a lot of surveyors tell me that they had somebody on the staff that wanted to be a surveyor, and they didn't have the heart to tell them they weren't ready, so they went ahead and wrote up a glowing recommendation, hoping that the board would stop it or the test they would fail the test. And with it being decoupled, that means that if they've done all that stuff and then they have fulfilled the education requirement, which would be the only thing the board would be looking at, other than the fact if their sponsor surveyor said he's ready to be a surveyor, then he gets to be a surveyor.
Yeah. Well, and one nice, and just sort of maybe to kind of give everyone a warm, fuzzy blanket, that's the decoupling seems to be happening industry-wide. You know
Right.
what I mean? In other jurisdictions with other industries, and so it's not like you're going to be the outlier here. You know, actually, you're kind of moving into, it appears to be more of a general consensus.
Well, it's not a bad thing for the surveyors have to take more responsibility to the people they send for licensure and really feel good about them before they send them in. I mean, that's a good thing. That's all I had. I guess we need to decide credit hours.
Synchronize your watches, gentlemen.
It's like 11 o'clock. Make a motion for 2 PDHs.
I second.
You have a motion for 2 hours and a second. All in favor say aye.
Aye.
Motion passes, and then I guess at that time we can stand adjourned.
All right, thanks, sir.